Hey everybody, welcome back to DDJs Inferno, the show where we discuss issues relevant to men and MGTOW. If you look at the top screen, I've been testing out some icons for my Q&A thought, Lily Even 32. I've got a little succubus on the left-hand side in her colors. I thought it might be kind of amusing, given that she is the Q&A thought. Today we have MGTOW Esquire, and we're going to be doing another episode of the Layman's Legal Clinic. And today we're going to be discussing primarily guardian ad litem's, parenting investigators, and parenting investigations. And so this will kind of give a primer to people who may be going through parenting investigations or people who've gone through them to kind of understand what the process, if there were aspects of it they didn't understand. But most importantly, it's for those people that maybe 6 months down the road end up in a family law situation where a parenting investigation is going to happen, and they should have an idea of what to expect so that they're not so afraid of the unknown. Because that's really one of the big challenges in family law, is that you don't know what to expect. You don't know what to know. You don't know what is right and what is wrong as far as, like, if the train is going off the tracks or not. And so by the time you figure it out, usually it's too late. I noticed that there's some entertainment value in the chat. Good looking out, Sonny. Thank you for showing up, Sonny. Nuke Europe. Apologize about the ban. I tried to get you unbanned, but I was overruled. As far as the other people in the chat, I've actually turned down the moderation settings of my chat as time has gone on. So you'll notice that you should be able to type questions faster and not get timed out so quickly on the chat. Now, obviously, I still have it set up so that, yeah, the MooBot was part of Kraut's doxing server. Yep, we need to do a video about that, TFM. We need to actually do like a collaboration and talk about how MooBot needs to be called out for being part of the doxing server. Absolutely. So yeah, that's fucked up. So anyway, the moderation has been turned down a lot. Obviously, links and caps are still an issue. And also, if you're a subscriber to my channel, I'm trying to make sure that you guys have icons that you can use. I'm not I think it's called a partner yet. I'm still an affiliate, so I only have a certain level of access to the different emojis that are there. But I have, in kind of a way to say thank you for your subscriptions, I have set it up so that a lot of like the timeouts and a lot of the other things like the links and such, you're not affected by that as a subscriber, to kind of give you a little bit more benefit for a subscription. And again, this channel is a work in progress as far as this live feed is concerned for Twitch. So just kind of an FYI there. The icon for Lily on the left-hand side, on the upper left-hand side of the screen, may not be the final version of the icon. I might bounce it around with a few different ones. So if you like one more than the other, let me know. You can reach out to me if you look at the bottom of the screen. My new website is up at missandrytoday.com. You can direct message me there. Obviously, I no longer have a Twitter account, but you can direct message me on Gab using the direct messaging function. In addition to that, you can direct message me on minds.com. And of course, on my YouTube channel, you can always go into the comments, and in the About section, my email address is there at missandry.happens@gmail.com. Before we get started, I just kind of wanted to touch base on a couple things here and kind of get a little meta for a minute. Wow, it's been a wild ride since October. You know, TFM mirroring my first video was awesome and kind of a nice way to roll out my channel. I made my first video about the social media constitutional crisis, and one of the things I talked about was a Supreme Court decision that came down that showed that the First Amendment rights to free speech applied to social media, and that social media was considered to be the public square. And they ruled against barring somebody from social media because of those things. And this was a U.S. Supreme Court decision. And I told people, I said, look, I think that this is the basis of a lawsuit. I was very clear. Obviously, my sound wasn't great. People would complain about it. It was my very first video. I really didn't know what I was doing. But the video was very well received. There were some people that were like, they just, they were like, oh, DDJ, you don't know what the fuck you're talking about. And I'm like, yeah, whatever. Well, now we fast forward to February 20th. Give me a second here. I'm going to see something here. I apologize. I had a siren go by. I apologize. I just want to make sure it wasn't going to give too much sound to you guys. So we fast forward to February 20th, 2018. And I think his name is Jared Taylor and a few other people. Let me see if I can pull up the information here real quick while I'm talking to you. Jared Taylor filed a lawsuit against Twitter specifically. And he filed it. Let me see if I can find it here. He filed it in California in San Francisco County Superior Court. And he filed it on the 20th. And it was Jared Taylor and the New Century Foundation, a Kentucky non-for-profit trust, against Twitter. And basically they're going after them under the same grounds that I talked about in my video back in October. And they actually use the Supreme Court case I cite in my video in their 30-page complaint. Originally, when I saw it, there's a website that they have. I don't have the link to it right now, but I'll try to put the link to it in the description of this video. And basically, they're crowdfunding for the legal fees. I encourage people, if you can, support them. I'm not associated with them. I'm not paid by them, but I've read the lawsuit. I think it has merit. I think that there's some things that they could do a little better, but it's a good start. And if you're in the legal profession, you understand that, you know, your complaint, you don't necessarily need to plead every little thing in your primary complaint. You can always amend the complaint later and add different things. I think it's a good first effort. And I think that they need to be supported. And the fact that they actually are using the free speech arguments, I think is fantastic. Because obviously for those people in the United States, you understand First Amendment rights are extremely important. And with that in mind, I'm also going to be doing a follow-up video to my last Twitter video that's going to incorporate some of that information. And I'm going to kind of share a little bit of commentary based on the lawsuit, based on my experience with Twitter, and as kind of a response to this complaint, so that hopefully it might provide a bit of a different context to what it is that they're doing in a hypothetical sense. But with that out of the way, just kind of an FYI, I notice there's a lot of people here that are kind of regulars. So MGTOW Esquire, go ahead and introduce yourself.
Attorney in an unspecified jurisdiction that I handle matrimonial law cases and family law cases, child support and custody. I've been a litigation attorney for about 17 years now. Nice.
Okay. So today we're going to talk about GALs and parenting investigators. So for the audience, kind of give us a little bit of an overview. What is a guardian ad litem? What's the difference between a guardian ad litem in a divorce as opposed to like a dependency action? Kind of talk about that a little bit for me, would you?
A guardian ad litem is typically either, well, usually they're appointed by the, actually I think they're always appointed by the judge or the court to see to the interests of a party who routinely can't appear in the courtroom with, so they basically represent the interests of minor children or somebody who has a disability that precludes them actually coming into court, or they don't even understand their own interests because of a disability of some sort. That's their principal function. There's a lot of confusion even in the legal community about how these guardian ad litem attorney for the children types act and what laws they have to comply with and what their role is even during the course of a routine custody matter. DDJ has pointed out in numerous streams before that they have a very specific role as in the statutory law, and as a consequence, judges don't always hold them to those standards strictly as they should. I hope that was a satisfactory answer. I think you mentioned the parenting investigators. Go ahead.
Let me touch on that a little bit. So one of the things that I noticed in my experience in family law is that when it comes to GALs in the context of a divorce or a paternity action, as opposed to a GAL in the context of a dependency action or a parental rights termination or a CPS case where Child Protective Services is involved, the guardian ad litem is a party. So in other words, they are like MGTOW Esquire said, kind of building on that. They are there to protect the children's best interests because they want to make sure that the children's interests are paid attention to as well. And so in the context of a parental rights termination, in a context of a child protective services action like a dependency, they're a party, so they can file motions, they can they can cross-examine witnesses. They basically function as the child's attorney and the child's advocate. And so a lot of times these guardian ad litems are attorneys. Now, the difference is that when you switch it from social services and parental rights termination and parental rights dependency actions through child protective services to a traditional private party divorce or a private party paternity action, the guardian ad litem ceases to become a party under those two sets of circumstances and becomes what's called a fact witness. So in other words, they're basically a witness appointed by the court to investigate, but they still testify as a witness. They're not allowed to file motions. They're not allowed to do any of the things that a party or a party's attorney would be able to do, because their function is that as a witness, not as a party to the action. So in other words, they're not a third party to the action. And the reason that crossover exists is because these guardian ad litems, if they're attorneys especially, they will appear in front of the same judges, in the same courts over and over and over again on a variety of different cases. So, let's just say on Monday, they might appear as the guardian ad litem who's a party to an action for a parental rights termination twice. But then on Wednesday, they're in the middle of a divorce case as a guardian ad litem / parenting investigator in the context of a divorce case. The judge will see that person so often and will default to treating them as though they are a party to the action and not as though they are just a witness, if that makes sense. And that's where the confusion lies, and that's where a lot of the abuse starts.
Yeah, statutorily, as it's written, it's a little murky. Even digging the facts of what you just said out is not a simple matter for just any attorney to find. It takes a while to dig that out. So yes. It's not surprising that it's really not surprising that a lot of GALs and even the judges don't know that.
Exactly.
Because they're very accustomed to dealing, and what it is the truth is these judges implicitly trust the GALs because they're always in their court, and it's usually one GAL's appointed. My experience has been that it's one GAL's appointed to that courtroom, and they don't typically take other ones.
Right.
I've had GALs who got moved into a court, and the judge just got rid of them and switched in their own GAL. Because they have a specific judges. They should be impartial, but as any MGTOW will know, they're not impartial. They have their own agendas, and their GALs tend to mirror their agendas. So
correct.
I've seen some very good ones, and I've seen some very bad ones. So
well, in Washington,
it's a crapshoot, but odds are good you're going to get a bad one. So anyway.
No, you're right. You're right. I apologize for talking over you.
No. I'm sorry.
No, you're good.
It's your
show.
Good.
We're going back and forth here. This is our show. It's not just mine. So one of the things that I've noticed in Washington State, and this is one of the laws we had changed back in the late 90s, was that guardian ad litems were actually acting as commissioner pro tems as well. And so what a commissioner pro tem is, for those that don't know, they're sort of like they're like an appointed judge. So the judges who are elected, at least in the jurisdictions that I'm familiar with, they will elect commissioners underneath them to hear the minor cases so that they can lighten their caseload, because family law is congested, just as congested as any other kind of law out there.
Yeah.
Well, when you don't
a
have
little more than most. It's a little more than most.
Exactly.
In my jurisdiction, we have a swarm of referees for every single family court judge.
Right. So and so referees would be the commissioner, the version what we call commissioners in Washington State.
Precisely.
So, but they also have pro tems, which are like temporary referees or temporary commissioners, where basically if the commissioner's sick that day, or if there's a conflict of interest and the commissioner can't hear a particular case, they'll bring in a pro tem, or they'll bring in a substitute. We'll call them substitute referees for that case, and then that they'll hear that case and they'll move on. Well, what the guardian ad litems were doing in Washington State was they would get together and they would fix cases. So they would have one guy who's a GAL would sit on the bench as the pro tem. The other guy would be the GAL and would ask for relief. The pro tem would give the GAL whatever relief he wanted, including attorney fees. And then the next day they would swap and do the same thing for each other. Well, it was bad. It was really bad. And so it got to the point where the state of Washington, we brought it up in front of, this was back when I was an MRA. We brought it up in front of the state legislature, and we actually had the law changed.
Yeah, it's some pretty sick shit. Gone through a lot of changes over the last 40, 50 years, and most of them have not been good. I mean, as you've discussed numerous times, the justice in the family court is a virtually non-existent thing in most cases. So,
yeah, I agree with that completely.
But an awareness that it's bad, and I don't know. I have my own instincts on these things, and I've noticed an interesting trend that I'll lay you a bet most of the listeners are not aware of. Even an attorney who goes into family court and represents himself is likely to get hosed. Yeah. The best chance you have is having an attorney who is not you. So while you may know the law and be able to set the record and get things ready for an appeal, you may also find that you'd be better served by having an attorney, because the judges are more likely to listen to an attorney than they will to a pro se party. Right. They don't have the right. It's not the way it should be. It's just the way it is. It's a rather disgusting trend. But I've seen too much of that, and the results are never good when somebody represents themselves.
I agree with that completely. And usually it's because they just don't know everything that's going on. So, and by the way, for those people that may hear some stuff in the background, it's actually it's hailing here. So if you hear that bouncing off my window, I apologize.
Yeah.
But yeah, it's crazy. So let me ask you this. So for somebody who gets assigned, under what circumstances in the context of a divorce case do GALs or parenting investigators get assigned in your experience?
My experience is the level of contested custody, and whether how they're assigned is another matter. But they're usually it's contested custody where the interests of the child have to be brought into question, where the parties have not already previously agreed that the child's going to have residence here, and we're going to have joint custody and visitation with this schedule. That's when they start appointing them. So, right. Yeah, it's a fairly standard in a contested custody issue to bring them in.
Okay.
Sometimes they get appointed where they're from the Legal Aid Society, and those, sad to say, are typically the worst ones.
That's true. That's so true.
It's sad, but they're not all bad. I've seen one from the Legal Aid Society. It was extremely good. But the private ones are a little better, but not always, because they always have their own axe to grind. And there's a few that are actually very competent. So it's the private ones, they cost quite a bit. Almost as much as a private attorney does just on any other matter, but usually the parties will share the expense. Usually the man pays the lion's share of it.
Right.
Shocked to hear that, but that's the way it proceeds.
Yeah, I agree with that completely. So typically, it's been my experience working with GALs that usually once they get assigned, they usually do like an initial meeting with both parties, and they look at the court file. And then they sometimes will issue a questionnaire out to the parties to kind of give some background information on the family and to give their perceptions on kind of everything that's going on. What's been your experience, MGTOW Esquire?
My experience is their principal interest is to speak to the two parties outside the presence of their attorney, and then they want to talk to the kids. They want to arrange a meeting with the kids. That's where they go. And then they'll go directly to the school counselor. The good ones will go directly to the school counselor as well. They'll take into account the suggestions from the parents, and they'll actually start investigating the claims that are being made by the parents. The best ones I've seen will actually listen to what both sides actually say and compare it to what they've been able to see from the proof that's in existence.
Right.
You know, I had one case where the allegations from the one side were so outlandish and ridiculous that as soon as she spoke to my client, she realized the other side was just full of shit. And it was night and day. The entire temperature in the courtroom shifted, because my client was a big guy. He looked kind of like a thug, and there was no way it was going to end well, right up until the point where I managed to press the case to the GAL, and she listened. And once she listened and she realized the other side was full of shit, the dynamic of the courtroom, every single part of the case changed completely.
Right.
So if you can win them over, if you can get through their ideological bias, if they're bad, if you can get through their ideological bias and get them to listen, which is not an easy task, it will change the entire dynamic of the rest of what happens.
Yeah, I would agree with that completely. The other thing that I noticed too, in at least in the cases that I've touched and the guys that I've talked to in other jurisdictions about, and you can kind of share your experience as well. A lot of times, what the GALs will do is in motion hearings, they'll actually testify to the judge. Is that your experience as well?
Yeah, I've seen that too, and it's it's shitty, and sometimes the judge doesn't know the law well enough to understand that that's evidence that's being offered, and not just the opinion of an attorney who's representing a client. It's just they're offering it as evidence. So it's shitty, but I've seen judges do that and just allow it regardless of what objections are being offered.
Right. And one of the things and the reason I bring that up is because in the context of the dependency action or the parental rights termination, when social services is involved, the GALs are actually allowed to do that because they're parties.
Right.
So they're allowed to speak from the bar, which is so when they talk about the bar, they're talking about when you go up in front of the judge, when you're speaking to the judge, they're saying you're speaking from the bar. For those that don't know, that's a term of art
Right.
in the legal field. But they're allowed to do that, and so what ends up happening is that they end up doing this in the context of their of like divorce cases and paternity cases as well. And when they do that, that's where shit starts to go sideways. And I agree with you completely. Yeah. The judges don't know, or they don't care, and they just allow these GALs to start testifying as though everything they're saying is fact and none of it's been tested, when the reality is that they're offering testimony. And it's funny that you bring that up, because this is actually one of the things that made me basically so much in demand when it came to paralegal work, is that in Washington State, once I realized they were fact witnesses, I started telling the attorneys to object, and then to take those objections up on interlocutories. Mm-hmm. And so one of the things we would do is, so if the GAL started testifying, we'd be like, Your Honor, this is a motion hearing. It's an argument hearing. It's not a testimony hearing. We were not ready to cross-examine the GAL. And you watch the judge look at you like you're an absolute idiot, because they don't understand what you're talking about. And they're like, wait a minute, right. You're going to cross-examine the GAL? And you're going to be like, well, no. You see, in Washington State, when you cross-examine a witness, and especially if they're an expert witness like a GAL, mm-hmm. they're supposed to provide you their documentation 60 days before the hearing that they're going to testify at.
Right.
Well, if they never do that, you know as well as I do. So one of the things they do is they'll show up and they'll try to ambush one side or the other. Mm-hmm. So the way you stop that is you say, look, this is a fact witness. We were not told what the witness is going to testify to, or that even this was a live testimony hearing. I'd like a continuance so that I can determine whether or not I need to do additional discovery on the witness, and so I can prepare cross-examination. And once you take it up on appeal once or twice, everybody sobers up.
Yeah, they do. They really do. It's a hilarious thing the way judges, but it's funny because it really depends on who you're representing and how you're doing it, because the objective is to take care of the client, and it's sometimes it's miserable, but it's true. You just have to keep the judges honest as best you can. And it's the funny thing is, so many of these judges, they know the law as a general sense,
right?
But they don't always know the specifics of every single area. I mean, it's a funny thing that the laymen typically don't understand, is that oftentimes attorneys, they think like attorneys, which is the critical ingredient to becoming one, but it doesn't mean they're going to know every aspect of the law in every single area. So
Right.
it's not surprising. It's really not surprising that judges don't know this. And
Well,
oftentimes they'll believe very firmly that, yeah, oh, I'm right. Yeah, I'm right to shoot from the hip in this case. No, you're not. Surprise.
exactly. Yeah.
No, you're not. So
Well, that's why they call it the practice of law.
Yeah, it really is. It's just trying to get these things pushed through and trying to do it in a persuasive way where the judge doesn't get so pissed they're going to look for every single way to fuck with you and your client. It's not the easiest tap dance to do in court.
Right.
So.
I have a question real quick from chat from Karoy, otherwise known as Kike the Dyke. Just so you guys know, Lily actually has access to the Bukkake chokeslam questions, so she grabs those as well. And yes, I obviously I look at them as well, but she has access to the Bukkake chokeslam questions. So whether your question is in the chat or whether your question has been through the redeeming of the Bukkake chokeslams in the lower right hand side of the screen, just rest assured, Lily's got that. So, but yeah, I agree with you completely, MGTOW Esquire. It's like they don't necessarily know the laws, they don't keep up on them, or some key element of the law has changed and they've not been briefed on it yet.
Or they're enjoying three martini lunches before the hearing.
Or breakfast.
I've experienced that too. That's really a trip when that happens.
It happens more often than you think it would.
It happens way more than it should happen.
Right.
So
I don't know, man. A Grey Goose martini sometimes. I'm just saying. I'm not a hater.
It just calms down the nerves so that they're able to actually get the gavel to bang it down on the table without actually missing the little place where it's supposed to hit. Just settles the nerves just right.
Exactly. That's funny. So yeah. So one of the things that I used to do, the other thing I used to do is we used to issue subpoenas to the GALs.
Mm-hmm.
And so, and the way the subpoenas work in the jurisdictions that I'm familiar with, and I know they're different in every one, so just kind of FYI, once you're under subpoena, you have a duty to provide updated info as that info comes up. But one of the things you want to do is you want to make sure that you do an updated subpoena anyway, just to cover yourself. But if you issue a subpoena to the GAL and the GAL doesn't provide you the information they have, and then they try to bring it up later in court, you can have that excluded from testimony.
Yes.
You want to talk about that a little bit? That's kind of a discovery sort of thing, but
well, it is a discovery related thing. Basically, it's what the legal concept behind it is unfair surprise. If let's say the other side has this smoking gun testimony that they're planning on springing on you, and you've already asked a question that piece of evidence would be responsive to. So the way you deal with that is to say, hey, Your Honor, if they'd have brought this to our attention, we might have had some conversations about its probative value of this piece of evidence being offered. We might have settled the case before we even got here. They're just springing it on us, so we're asking for this to be excluded. That's an area of law that evidence gets thrown out, and right. That's why it's always a good idea to answer discovery honestly, because specifically for the man, if there's evidence that the X is a crazy drug abusing cluster B lunatic, and he's actually got evidence of that, and you don't actually bring that in to the discovery so the other attorney sees it coming, so that the other attorney can try to settle it, backpedal and not be making assertions to the judge that are unfounded.
Right.
And you don't want it to get excluded. You don't want your stuff to get excluded on that basis. So you don't ever want to just hide shit like that, hoping to spring it at the last minute, because it's not going to work. So right. That's, and similarly, the other side tries to do the same thing. They're going to wind up with egg on their face more times than not. I mean, exactly. The judge may want to hear it, but it doesn't mean it's going to come in.
Well, and that's one of the things that I see that's the biggest in family law, the biggest mistake that attorneys make is not doing discovery. And then that is especially true when it comes to GALs, because a lot of times what will happen is that the attorney will call the GAL and say, hey, what's your thoughts on this? And the GAL will give a casual response. And then when you get to court, you'll find out the GAL only told you half the story. And so one of the reasons that we did discovery and we did subpoenas, we would not only subpoena for the evidence in the case, we would also subpoena their curriculum vitae and their resume, their experience, their training, all of that, because we want to know who we're dealing with. And let me kind of give you kind of a personal story, a personal anecdote of why that is important. In my first divorce, I actually did my own trial, and it was a 5-day trial. And I had the GAL on the stand for a day and a half of court time. And that was cross-examination.
Sounds like a blast.
Oh, it was so much fun. Oh my God. It was so therapeutic.
Yeah. Well, you get some rabid feminist lunatic, odds are good. Even legally trained ones are going to lose their shit at some point.
Exactly. Well, this guy, he was the former county bar president. He set up and created the GAL program. He was a former commissioner pro tem. He'd run for election and failed a few times. But I mean, very, very heavy gun. And I had him under cross-examination, and we were talking about the subject of sexual assault. And he tried to say that he was an expert in sexual assault. Now, I had previously had I had the director of the sexual assault center for my children. I had the director testify. And the director was so qualified that she actually was training other people to become experts. That's how much knowledge she had, academic and experience. And she was the second most qualified sexual assault examiner on the West Coast. He was there trying to rebut her testimony. And so he got up on the stand and he literally, with a straight face, he said that his CLE that he took on sexual assault was carried the same weight as her medical PhD, all the specialized training and everything that she had.
Holy shit. Oh, that's awesome.
Yeah.
That reminds me of, your search really doesn't equal a law degree. It really doesn't.
It really doesn't.
I know you did a Google search, but that doesn't really quite cut it.
Right. So one of the things that he had talked about is that he had actually worked with a lot of people that had sexual assault, both in the context of GAL and in the context he worked at a group home before he became an attorney. So he was talking about how if somebody had all this experience, all that experience trumps the academic education. And my argument was you need both. You need the training and you need the experience.
Right.
And so one of the key questions I asked him, which actually, I mean, it was awesome. So he's furious because I'm just fucking with him the entire time. And I asked him the question. I said, so you're saying that your experience, your 15 years or 18 years of sexual assault experience qualifies you as an expert? And he says, yes. I said, so if I understand you correctly, to clarify, what you're telling me is that if a woman had been raped for 15 years and she has a GED, she's now an expert in sexual assault.
That's well done. That's a very good way of asking, because you really do put them on a nasty little horns of a dilemma. They get to answer it one way or the other, and neither one's going to serve them very well.
Well, he rose out of his chair.
Mm-hmm.
He grabbed both sides of the chair and he rose out like he was going to lunge at me. It was awesome. It was awesome. And it was, like I said, it was very therapeutic. What the point is that at the end of the trial, they were trying to go for supervised visitation. They were trying to do all this other stuff. And most of his report got thrown out because of it. So that's good. If you do your discovery, and this is the thing that I tell everybody out there, if you do your discovery and you extend that discovery to subpoenas and to requests for documents from GALs, you are going to be far better served than not doing it. Because what will happen is that GALs are very narcissistic. And so when they go into court, they're going to be like, well, in my opinion is this, and my opinion is that. And then you find out that they don't have any experience in that area, or they don't have any academic training, and they've not gone to an expert, and they're just talking out of their ass. Now you can call them out.
Right. Yeah, I have a couple cases. That kind of stuff is exactly what I'm going to do. It's
Yeah.
makes for some lively court time.
Well, and what's nice is that all of a sudden the judge perks up. The
Yeah.
judge is like,
Well,
because the judges get bored. So
oh, well, if they haven't had enough martinis, too much blood in the alcohol stream, that's what's going to happen. They're going to fall asleep behind the bench, prop themselves up on their gavel, and you start talking about some exciting stuff like a verbal exchange with a uh, narcissistic GAL. You're going to wind up waking them up.
exactly.
There's a little theatricality to court. There has to be, otherwise you're going to wind up with a sleeping judge, and no one's going to get the judge to even pay attention enough so that when any relevant evidence actually comes right by them, they'll miss it.
Right.
You gotta have them paying attention.
Well, and I think that's really important because again but it's also preparing. So like to reiterate, and I can't reiterate this enough for those people that are out there. If you're in a situation where the GAL in your jurisdiction is defined as a fact witness, then if he starts testifying or she starts testifying from the bar in motion hearing, you need to make sure that you object. And you need to ask for a continuance so you can prepare to cross-examine. And that's a reasonable objection. Any litigator is going to tell you that if they start taking evidence when they're not supposed to be taking evidence, asking for 2 weeks to prepare is not unreasonable. I mean, what's your thought on that?
It isn't. You really do have to do that. But the trick, and this gets back to my original point, the it really is a sad fact that judges tend not to take pro se parties seriously.
Correct.
It's something that your attorney has to do, and that's I've seen attorneys represent themselves in family court, and some of the shit they do is insane.
Oh, they get wrecked.
The truth of the matter is, I think I'm not even sure I'm getting this quote right. It's an old Mark Twain quote: "The attorney who represents himself as an idiot for a client and a fool for an attorney."
Yeah, that's about right.
So, or if it's the person who represents himself, I'm not sure, but I know that there's a certain, it's not quite a zero fucks given thing, but there's a certain, because I actually really care about how things turn out for my clients, but I'm not directly involved in it. So I've got a little bit of dispassionate look of it, and having a cool head improves the odds of being able to make an argument that something's unfair and having it listened to, as opposed to being very personally invested, and getting up and pounding the table. That kind of shit never works well.
No.
So.
And I've talked to attorneys who have attempted to do that method just as like part of their theatrical thing. And
that's dumb.
Yeah,
that's
and
dumb.
they've all told me I abandon it. It doesn't work.
No, it doesn't. There's some parts of that you can get away with if you're not too over the top. But there's 9 times out of 10 it's off-putting.
Right.
So just the it's like you can get away with humor, but not too much. There's bits and pieces that you can do, but bits and pieces that you really shouldn't. And if you try to do them, you're going to wind up having it blow up in your face.
Right.
So, but it's that's why I as much as I feel for my clients, and I'm really looking forward to the day where I could start doing this pro bono. But it's just these guys who go in. It's like watching people fly into a bug zapper. When they try to do it alone, it never ends well because the system grinds them up.
Well, the system is designed to grind them up. Absolutely,
it is completely. And I'm not even sure when that change occurred. Probably before I even went to law school.
Yeah, I would say it
got
probably happened
bad
with Duluth.
Yeah, Duluth was in the 90s, wasn't it?
80s.
80s. All right. I'm just trying to remember when Bork's book came out, The Political Selection of the Law.
Right.
That was I think that was a pretty yeah, it was about the same time period. It was after he was prevented from getting on the bench rather.
Right.
Because he was just, it was so manifestly unfair what happened with him. And it really did screw up the courts completely.
Right.
So but that's been a political poisoning of the entire legal system, and that's where these things all come from. So
Yeah, I agree completely. You know, and that's the thing is that it's you know, when you're looking at these situations and you have to be able to game the system, it's hard to game the system when you know it's set up against you. And I guess the thing that I would say to anybody who has to go through a family law situation is this: your number one priority would be to cover your ass and to double check everything that you do. And so in dealing with GALs and applying that to GALs, and again, I can't stress this enough, if you have a piece of evidence, like you have a psychological report, or you have a medical report, or you have a police report, or you've got some other tangible evidence, make sure you provide that to the GAL and make sure you send it to them certified mail so they can't say they never got it.
mm-hmm.
Because
Yeah, that's critical.
it is. And the reason is because, again, many family law cases don't set themselves up for success, and they don't do traditional litigation. They want to do death by 1,000 motion hearings rather than actually go to trial. And if you set your case up to go to trial and you force that trial to happen, now you have that GAL on the stand under oath. You go,
Right.
well, you know, Mr. GAL, you know, on the 12th of January, I sent you this police report. Did you review it? No. Well, why not? You know, now all of a sudden you have them in a corner. Now you have things to talk about.
Right. And you need to do that. And that's, you know, it's unfortunate that the system and every single cog in the machine is geared against fathers, basically. And
Right.
that's where things get really hairy. And it's because of this idiotic trend of social justice that's been sweeping across the nation for years, with nobody opposing it.
Right. Right. And
So,
I would agree with that
it's
wholeheartedly.
and it's standing up in opposition to it is critically important. And I wish there were more attorneys doing it, but most law schools are indoctrination centers, just like colleges.
Well, I agree with that completely. And, you know, the other thing too is that's the other part of the reason that I wanted to do these layman's legal clinics, is because I think it's important to teach other attorneys this stuff. Because, you know, even when I was, you know, contracting to attorneys and speaking with people on a daily basis, most of the attorneys didn't know this stuff.
No, they don't.
And they had no clue. And when you share it with them, you just watch their eyes open. It's like you've given them a red pill.
Well,
And
yeah, I mean, but you know, honestly, even your own work has helped me. It's just there's bits and pieces that you don't think about when you're practicing law. You just don't think about it. It has to be brought to your attention. And once you do, and it's funny because you've made some assertions in your streams that when I first heard them, I went, that doesn't sound quite right. And then I look it up, and it's not framed or phrased the same way as the law puts it, but the factual de facto effect of what you said is exactly what the law says. So you weren't misstating the law at all. I was just not. It's just not the way the law says it, but the effect of what it is. You didn't frame it exactly the same way as the law put it.
Right.
Which is amazing. It's like what you were talking about with Gloria Allred. You know, that was absolutely factually correct, but it wasn't framed the same way as what an attorney needs it framed as to understand what you're saying. So it really takes a little bit of processing to get that data through.
Yeah, I said it in layman's terms.
Yeah, yeah. So it's funny, and it also amazes me how most attorneys, like 90% of them, think a certain way. They're trained to think that way, and it's hilarious when you watch one who's been given a piece of information that they can't process. They just can't. It's fun to watch because I've seen that more than a few times.
Yeah. Well, and that's
attorneys who've never done anything else. That's a pretty good example.
Right. You know, and that's the thing, though, is that's usually where a lot of the disconnect between attorneys and clients comes through, is that very rarely will you have somebody who can speak both legalese and speak in layman's terms in order to translate to the client. And that was one of the things that I would always go out of my way to attempt to do. And it was funny because, like, once I would get on these cases, and not to toot my own horn too much, but I mean, I would get people that would come to me and go, you know what? I haven't slept this good in a long time. I feel like there's a light at the end of the tunnel in my case.
Yeah, I've been getting that a lot lately too.
Yeah.
The initial consultation with my clients, it is funny, watching them be able to walk out and breathe. So, because they come in and they're just a mess. So they've been trying to fight with this lunatic for the past year or 2 or 3, and they're just looking at it going, this is never going to end. This is just never going to end. Right. and it's awful to see what they've gone through before. And if they'd only just moved earlier, put themselves in a position where they could actually move forward. But, the system, every single aspect of the system is designed to grind people up, and it's really unfortunate, but that's the way, this is the world we live in, not the one we want.
Right.
So,
well, and I would say that, for the attorneys that are getting into family law, like the newer ones out there, they need to do some criminal law, even if it's misdemeanor, because they need to do trials. They need to do trial prep. They need to be able to do discovery from start to finish and see what those processes look like. I mean, even if they only touch 6 cases, they just need to go. They just need to have 6 cases where they can actually go and litigate it from the beginning of the case to the end of trial. And actually, they should be cases that go to trial as opposed to cases that settle. Because the thing about family court attorneys is that family court attorneys only have a legitimate trial maybe once every year to once every 5 years. They don't go to trial very often.
No, they really don't. Not most of the time, because usually one side or the other loses their nerve. That's one of the advantages of having been a litigation attorney primarily prior. I've done plenty of trials, so it's kind of funny because one of the conversations you and I had off stream was that there's 2 types of attorney. There's the administrative and there's a litigator.
Yep.
And you can always tell from their writing what kind of attorney they are. A litigation attorney, when they make a demand letter, it's never more than a page long. And if you just boil it down, it basically says, you and me are going to fight. The administrative attorney, they will explain chapter and verse everything in the case and why they think they're going to win. And their demand letters are about 15 pages long.
Right.
They expect that they're going to fire one shot and win. Right. And the litigation attorney fires off a letter that says, you and I are going to fight. And that's basically all it says.
Right.
I am demanding this thing that you can't possibly do, and you got to do it in a time that you couldn't possibly do it in. And if you don't comply, we're going to court. So it's basically, you and me are going to fight.
We're going to fight no matter what. Yeah.
And it's funny because administrative attorneys look at litigation attorneys, and I actually saw this. This was hilarious because there was an attorney in one of my cases way back when who was fired in favor of me, and the communication was, "I don't practice loose law like that." So I'm loose and I'm cheap, I guess. But it's just the basic bottom line on that.
But here's the thing:
there are attorneys who are willing to fight regardless. They don't really. Oh, go ahead. I'm sorry. I'll shut up.
Yeah. No, that's fine. Here, I just want to interject something real quick. Mm-hmm. The thing that they didn't understand, though, is that even though you're loose and cheap, you're the one who's doing the fucking.
That's pretty much it. Much it. It's very much like. I'm not even gonna go to that analogy. But the basic point is, if you get a general who actually fights, who's actually willing to fight and not just worry about the logistics of every single fight. I'm not going to commit troops to this battle because, we don't have 100% of the food and ammunition reserves. Stalingrad is a perfect example of that.
Right.
They didn't have the ammo. They sent out 2 guys, one gun between the 2 of them, 2 or 3 packs of bullets. And they said, just go out and fight. You have no choice. We have to keep this. Otherwise we're all dead. That's the kind of thinking a litigator has. We just have to go fight. We don't have a choice. We have to fight. And we're going to war, period. There's I'm not waiting for the perfect time to fight. We're going to go fight. And that's the type of attorney that you want. You want one that's actually not just going to sit and wait until everything's perfect, all the T's are crossed and the I's are dotted. Yeah, you want somebody detail-oriented enough to see that, but you just... it was hilarious getting accused of being loose. It was priceless. I got a kick out of that. It's one of those gifts that keeps on giving. It's just too funny. That's what administrative attorneys think of litigation attorneys.
Yeah, well, and that's a problem with litigation with administrative attorneys is they're more interested in the dollars and cents per hour as opposed to did I win the case. And what they don't understand is that if you walk into a case, especially a family law case, and you get beat around the head and shoulders and you lose every hearing, then you take it up on the Court of Appeals and you win and you come back down, number one, nobody fucks with you ever again. And number two, you start getting clients left and right because they're going to go, this is the guy who can turn the ship right side up. This is the guy who can fix it. And your phone rings and you never have to advertise because word of mouth does it for you. And that's the thing that's important. And the other thing that I think that I need to reiterate, I know I've said this on a lot of streams, but I can never say it enough. If you're in a family law situation, you need to prepare for your court of appeals and what that appeal looks like. And you need to do it from day one. Because even if you do everything right, even if you do your subpoenas, even if you cross-examine your guardian ad litem, even if you do everything correctly, the odds of you getting fucked are still extremely high. Because these people will play dirty tricks on you. They will try to paper the court and try to drive your attorney fees up to get your attorney to drop your case because there's just not enough money. So you have to understand these dirty tricks exist, and exactly what MGTOW Esquire said is that the system is designed to grind you up and to spit you out. So you have to be able to prepare for the appeal from day one. And the only way that you can do that is to be able to collect your evidence, do your discovery, cross-examine everybody, and make the record. And the reason I bring that up is because last night there was a guy on the TFM show stream where the judge said to him, I don't care, I'm not hearing this anymore. When you know what that's code for, I don't want you to make the record.
Yeah, it's also it's typical behavior towards a pro se. I've had that experience myself. I had to completely shift the I hate this expression, the paradigm shift, but I had to have the judge and the guardian ad litem go through a paradigm shift to take my client seriously. It was a very touch and go bit, but it worked. And my client got a good result, but it was
in general, of course,
it was a bullshit domestic violence allegation, and proving up that it was bullshit was the key part. And we didn't have enough evidence to do it, but we were able to prove that the other side was just full of shit, and we got the guardian ad litem to realize that she was full of shit, and that's when things started to shift. This was, it's just. You have to have at least one granule of fact on your side that you can prove to start getting people to take a closer look at the arguments and evidence that's being brought in by the other side. If you don't even have that one, you're hosed. You may as well, make sure you got a second passport and head for another country.
Right.
Because once the allegations are starting to come, they're never going to stop. Once they find out once they find out bullshit allegations work, they will never stop making bullshit allegations. What gets rewarded gets repeated. And the other thing what gets rewarded gets repeated. That's an ancient axiom for the law. Whatever shitty behavior gets rewarded is what gets repeated constantly. Another thing on the subject of once you successfully appeal after a grueling bullshit battle, it does get the point across. It's very much like a war. The objective in war is not to kill people and break things. It's to break the will of the other side to fight. And litigation is very much like that. So propounding discovery, you do all those things in good faith, but the truth of the matter is the timing of when it's done and how it's done is what breaks the will of the other side. Right.
And that's why you need an attorney who's a good litigator, who is vested in your case to make that happen. Because, one of the things about that MGTOW Esquire said early on is that, basically only a fool has himself for a client, which is how I heard that quote previously. And that's really true. And it's because you're so emotionally invested and emotionally involved that if you don't have the ability to shut your emotions down and to look at things dispassionately and to look at them from an outsider objective standpoint, or to be able, or even to look at them as though your opponent might see it. In other words, look at it from the view on the other side of the table. It's going to create a lot of problems for you, and it's going to create tunnel vision, and you're going to miss opportunities, and you're going to focus on things that just don't matter, or they're going to be things that are irrelevant, or they're going to be things that are going to set you up for failure. So it's absolutely important to have an attorney, if you can get one, and to make sure that you have a good attorney on your side. And the very first layman's legal clinic that MGTOW Esquire and I did, we talked about how to choose an attorney. So for those people that, if this is the first one you guys have seen, and this might be something that you might find of use, or you know somebody going through a family law situation where they might find use of it, definitely share those videos with them, because this is the third one we've done, and it's nice because we've been able to do these deep dives and talk about various subjects in a way to help people out, you know. And again, once the Q&A session comes up, if people have legal questions, this is the stream to ask those questions on. Because it's an opportunity to do that. But I think that, you know, it's absolutely true that you have to be prepared for war, and you have to know how to fight and when to fight. And that's why having an experienced litigator is so absolutely important. And that's one of the reasons that I like having MGTOW Esquire around, is because he's got that litigation experience and he sees it firsthand from that attorney's perspective. And, you know, and I appreciate you coming out. So I just wanted to say that before we continue.
I love this stuff, and it's fun doing it. It's, you know, the other thing about that, and you said prepare for war, and it brought up one of my favorite Latin maxims. It's, you know, long and short of it is keep your pimp band strong. But the basic, right. the Latin motto is, if you seek peace, prepare for war.
Right.
Nobody fucks with somebody who's ready to fight. Nobody fucks with them.
Right. Not if they're smart.
You know, but yeah, but you know, weakness invites attack. It always, it never fails. You know, I was listening to the stream from last night. That's exactly what Sweden did. It projected weakness constantly. And guess what? they're heading for a fucking, and it's a total nightmare. It is. And that's true. That's true whether it's in a relationship, whether it's in a courtroom battle, whether it's in a war or a political discussion. Projecting weakness invites attack. Always.
Right. Do you have any other advice or wisdom about GALs or parenting investigations you'd like to share with the audience before we go to Q&A?
Well, I'll tell you, I haven't done this yet, but it's something that's been lurking in the back of my mind. I'm sure there's some good motions to disqualify GALs, just like challenging a judge for bias and cause, just to get them off the case. I know that can be done. I haven't done it, so I'm kind of talking out of my hat here. But once you get that CV, if you can prove up they're just absolutely biased and they will never ever find in favor of one side or the other, that's the kind of GAL who should be removed. And getting one removed from a case would be key. And I'd be interested in hearing what you have to say about that, because I have seen more than enough GALs who really had no business doing that work anymore. I don't know what they're really well suited to. Maybe meter maid.
Right. But mail sorter.
Perhaps. Ambulatory sperm bank. But
there you go.
It's just
I get it.
Biased people in a judiciary are an anathema to the legal system. They just are.
I agree.
If you're not going to do what's in the best interests of your clients, you have no business being there. And if you're in a fact-finding or findings of law position and you are biased one side or the other, shouldn't be there.
Right.
Anyway, that's just my soapbox.
Well, let me answer that, because I'll tell you what, I've actually had a couple of GALs removed.
Please.
So one of the things that we did in Washington State when we did the MRA thing was we actually changed the law to create a system to remove biased GALs. And one of the ways that we could do that is, so again, this goes back to your discovery, right? So you get a GAL assigned, whether they're from legal aid or somewhere, you don't know who they are, right? So the first thing you do is you shoot them a subpoena. You want to know who they are. You want to know their background. You want to know everything. And what's nice about a subpoena is it forces them to give you the facts under oath. So if they lie about those facts later on, you now have something to attack their character and to discredit their testimony. So that's important. So again, you're preparing for the war right up front. So you shoot the subpoena, and then they usually get offended. They're like, Mr. Smith, why did you give me the subpoena? Well, that's just what I do. You just kind of shrug your shoulders and be like, that's just my standard operating procedure. My paralegal prepares it. I just sign it and shoot it out. Sorry. And then, whatever. they have the subpoena, right? You shrug it off. So now you have the curriculum vitae. Well, let's say it's a child abuse case and they have no background in child abuse. Maybe they came from environmental law, or maybe they were a social justice warrior with a sociology degree. Well, in that case, now what you do is now you have that background. And then if they start spouting out of their ass from the bar, so there's a reason that you do all this. The reason that you object to them testifying from the bar, the reason that you do the discovery is because you want to be able to discredit those that shouldn't be there in the first place. And so you have the tools to do it right out of the gate. So now, once you have this stuff there, they start talking out of their ass, you make a standing motion to the judge. Your Honor, I'd like to make a motion right now to have the GAL removed. They're talking about things they clearly don't have any education about. They clearly don't have any academic knowledge about. They don't have any experience about this, and they're stating expert opinions without actually getting the experts involved. And then the judge is going to flip out on you. But then you can say, well, Your Honor, if you're not going to entertain the motion now, then let's note it on the calendar under special set, which is basically means that goes back to that judge. For those that don't know, you note it for that particular commissioner, so it doesn't bounce to somebody else who just kind of ignores it. Because what they'll do is when you have these types of motions, they'll play 3-card monte with the referees, and they'll assign a referee, or they'll assign a different judge or a commissioner, because they're trying to throw the hearing out. They're trying to throw the motion away because they don't want that person to get kicked off the case. So you say it needs to go back in front of you, and you need to make a decision on this. And this is the motion that we're going to file. And basically, it's called motion to remove GAL for cause. And then you show your reasons where the GAL is biased or they are incompetent in whatever field that they're trying to discuss. So, like if a GAL goes into a bunch of detail about finances, like say part of their parent investigation, they talk about the party's finances and this and that, they don't know what the fuck they're talking about. That's look, for these purposes, Your Honor, the GAL needs a muzzle, or they need to be removed. If it's a child abuse issue and they have no experience in child abuse investigation, or they have no experience, the big one, here's the huge one, forensic interviewing of children. So the only way to preserve a child, if you look at the best practices for child abuse investigations everywhere in the country, the best practices is that the interviewer of children has to be forensic interview trained. Now, what that means is, in layman's terms, is that you're taught to interview a child in such a way that you're not leading the witness. Once you lead a child, witnesses, children want to please people around them. That's just their natural thing. So if you're interviewing them in such a way that you're leading them, or you're giving them benefit when they answer the questions the way they want to, the kids will see that and they will change their answers to support your viewpoint. And that destroys them as witnesses if they're child victims of abuse, because then it looks like they're being coached. So if you have a GAL who's talking to the kids about child abuse, but they are not trained as forensic interviewers or trained as forensic investigators, they're done. Now, the reason that this is important is because even CPS workers, even Child Protective Services workers, are not trained as forensic interviewers. This is something that most people don't know. So, like when they do these safety interviews where the social worker goes to the child's school and interrogates the kid away from the parents, they're not forensic interviewers. So they're destroying the child as a witness under those sets of circumstances. So these GALs are much the same thing. So you're like, Your Honor, I'm concerned about the best interest of the children. If there are questions about child abuse in this particular case, or neglect, shouldn't we have a forensic interviewer come in and question rather than the GAL? Then the forensic interviewer can provide their report to the GAL, and we can actually have the specialist handle it?
Right.
If you bring it up...
That's exactly the right way to do it.
Yeah. So my whole thing is that if you bring it up and then show that the GAL should have known and they were incompetent, you go, Your Honor, this is law 101. This is child abuse investigation 101. If the GAL doesn't know it, maybe we need to get a GAL that does. Now all of a sudden,
that's some useful stuff.
Yeah, it's huge, and you can hammer them. And the other thing is too, is if they are under subpoena. So you've subpoenaed them for documentation, right? And they've not provided it, and then they ambush you. Now you have bad faith. Now you can go, well, Your Honor, I shot a subpoena. So, and talk about that a little bit, so to kind of explain it to people.
A subpoena?
Well, no, the bad faith thing, where if they hold back.
Oh yeah, no, bad faith is extremely bad, because that's part of what showing bias is. You show bias in somebody who's supposed to be impartial, you've basically just completely given yourself a reason to challenge them for cause and have them removed. It's very much like proving a juror is actually the accused brother. It's just they're never going to be fair. And once you prove they're never going to be fair, they get thrown off.
Right.
So that's the way to do that kind of stuff. Bad faith is lethal in these cases. While you have to have a good faith basis to be doing discovery and things. If you get proven to have bad faith in any aspect of a legal system, that's pretty darn crippling.
The other thing that we do to set them up is that so when they start testifying from the bar in motion hearing, the judge is going to say, "Well, no, I'm going to allow you want to refer to the GAL as the fact witness. You don't want to refer to him as GAL. You want to refer to him as a fact witness, or you want to call him the parenting investigator fact witness or the GAL fact witness. You want to get that language in there in order to make the record. And then if the judge decides that they're going to take the testimony of the GAL anyway, then you object again and you say, Your Honor, well, if you're going to take the testimony of the GAL, can you at least put the GAL under oath?
Yeah.
Once that happens,
it's key,
now
because you can cross-examine them. If you can't cross-examine them, you're screwed. And if they're just shooting from the hip, that's what happens in most of the cases. Is the GAL just shoots from the hip and testifies, and the judge is shooting from the hip and just taking the testimony as though it were, a fact. And that's the thing, is it's not supposed to be done that way. Procedurally, that's wrong.
Right.
And procedural errors will screw you up.
Always.
And they always screw you up. So it's just you never want to let that stuff slide. And the sucky thing is, most attorneys don't know that. Right. They just don't.
Well, and here's the other thing that most attorneys don't know too, to build on that whole testimony thing. Once they're under testimony, and this goes for any kind of testimony that's under oath, that testimony is under oath for all purposes. So if something else comes up later down the road and that GAL's testimony contradicts what they said earlier,
right,
you now have an issue of perjury. You have an issue where you can destroy character. And again, that's bias, bad faith. This is what kicks them off of cases.
And eventually it'll eventually get them kicked off of the roster to be called as a GAL.
Correct. And I have actually had that done once.
Yeah. I haven't seen that happen here, but I'm very intrigued by it in terms of the utility of getting that particular type of scenario set up for my clients, because I've seen too many of these GLs just behave badly. Right. And it sucks. It sucks when you see it.
Yeah, so, it does. It does.
And you just gotta have the knowledge, and you gotta execute the plan to get the evidence in front of the judge and get the GALs who don't know what they're doing off the case.
Right.
Or the biased ones, and I swear I've seen more biased ones than I can shake a stick at.
Oh yeah, most of them are biased. But I also think too, this is something that's important as well, is that this is the kind of stuff that you need a litigator for. This is the kind of stuff that this is not Law 101. What MGTOW and Esquire and I are talking about is not Law 101. There's a lot of years and experience and information that's out there. If you have the ability to have an attorney take your case, do it. And just make sure that they're the right attorney. Look at the first episode of the Layman's Legal Clinic to check it out. And if it's an attorney that is genuinely interested in helping you and they don't necessarily know, show them all 3 Layman's Legal Clinic videos. Let them see kind of what it is we talk about, and let them do the research for themselves so they can verify what we say.
Yeah, and that's a key point, because 9 times out of 10, attorneys, they're busy people. I'm much busier than I'd like to be. And the truth of the matter is, I don't know every fucking area, even in my own area of law. I wish I did, but oftentimes something will come across my desk, and I'll look at it and go, that doesn't seem right, and I'll have to find time to look that up. So it's just a question of, doing what's right, finding out what you can do, and then going forward with it. But as I said earlier, when it comes to litigation, you can't always wait until you have every piece of information. So you sometimes have to shoot from the hip just to get the shot off. Right. There's an old line from Heinlein that I absolutely adore. Get the first shot off fast. It'll often upset them enough that you can fire the second shot dead blank perfect.
Exactly.
So, you never want to yield the initiative. You press the attack as often as fast as you can. because that gives you a really good edge when it comes time to settling or finishing the trial. One or the other. But if you have the initiative and you have the case moving and you're driving the direction of the case, even with what you're doing isn't 100% right. I mean, I have won more cases that I should not have been able to win. I just should not have been able to win. And it's just a question of pressing your advantage where you have it and moving forward.
Right.
Being convincing and credible, even if you're not always 100% right, because I've been wrong. Shit, I've been wrong so many times, and I still won. And it really destroys sometimes it really destroys your faith in judges. But it's just because you find out 6 months later, I guess I shouldn't have said that.
Right.
Well, I didn't.
Yeah, but you know how to dance. That's what's important.
Yeah, you have to. And it's a funny thing. The world is just a strange place, and I guess the objective is that if you're trying to do the right thing, you just do the right thing and keep pressing your advantage, and you win in spite of yourself sometimes.
Right.
So,
well, you can never hit with the shots that you don't take.
That's exactly right. You just got to take the shots. It's you're not always going to hit. Hell, my batting average with law has been pretty good, but it's not perfect by any stretch. I haven't won every single case, not even close.
Right.
Some areas of law better than others. Matrimonial, I'm doing pretty well so far. So, but it's one of those, knock on wood. Let's just hope I don't fuck up the next case, because
exactly
these is people's lives. I'm doing my level best to make sure that my skill level is where it's supposed to be, but I'm never going to have a perfect skill level in anything I do. I'm just going to do the best I can, and the key thing is to take the shots, because if I don't take the shots, nobody else will.
Right.
So, that's.
I do want to say this. I appreciate your kind words, and thank you for following up on some of the things that I've said and confirming, that I was right. Obviously, I like people putting feathers in my cap. I'm not going to turn that down.
No, your track record for informative things is spot on. I've looked up a lot of the things that you've said, and I thought to myself, that doesn't sound right, but it always comes out that it was right. Just wasn't phrased in a way that I could process it.
Right.
So
I'll take it.
Yep.
So with that in mind, let's go ahead and open up the Q&A. Now, as an FYI for people that are relatively new, you'll see some Bukkake choke slams floating on the right-hand side of your screen if you're using Twitch TV or if you're on a desktop. You can redeem those Bukkake choke slams to ask questions, and you'll see them pop up in green. There'll be a little box. If you hover over it, the box will show up, and you'll be able to click it. There's a question mark on it. You click the question mark, and then it says redeem Bukkake choke slam, and then you get the points to redeem them. Or you can do what Lily has outlined in the chat. That is, if you have a question, you put question in brackets. She'll collect that question and then go from there. So with that in mind, let's go ahead and open up Q&A. Lily, what do we got?
Okay. So, first one, DDJ, are you ready for this?
Yeah, and can you turn up your volume just a little bit?
Can I turn up my volume? I can try.
Yes, you can.
Any better?
Yeah, it's a little better.
That's a little better. I feel like that's not at all.
No, that's fine. Keep going. So, the question for me.
Okay, question for you. DDJ, since Lily is a succubus, are you an incubus, which is like male succubus?
No, I'm more like a demon lord. So now you know.
Doomsday Jesus, man.
Exactly.
Oh, gosh. Don't fit in so well.
That's what she said.
Oh god. Okay. Next question. I'm not sure who it's for because it's not directed for anyone. I'm just assuming it's for DDJ. Why would a man call himself a dyke?
Kite the dyke.
It's not.
Kite the dyke.
It has to be. Let me kind of explain this to people that might be confused. As a masculine presenting transgender lesbian, ask yourself this question, and I want you to think about this. Is a rhetorical question. What is the difference between a masculine presenting transgender lesbian and a heterosexual male? Next question.
It's very much like what is the difference between dihydrogen monoxide
Right.
and and water.
Right.
But you can have an awful lot of fun with the really empty-headed nincompoops by saying, this dihydrogen monoxide, it's in our lakes, it's in our it's in the tap water, and it's a terribly corrosive chemical. It even grinds down mountains, and oh yeah, we gotta ban it. Yeah, okay, have fun banning water, dumb shit.
Yeah, exactly. Exactly. All right.
Just can't help some people.
No, you can't.
No.
Next
but
question.
But you can have fun at their expense.
Absolutely.
Go for it.
You can. When DDJ buy doll and make love to it like real man.
Say that again.
When DDJ buy doll and make love to it like real man.
I don't know. I haven't decided yet.
Say that with an accent, Lily. You really need to say that with an accent. Just any accent of any kind will work. Just go for it.
Any accent that's not mine. Got it.
Exactly.
Well, you have a your accent. I don't even know where you're from, but your accent doesn't seem thick enough to actually carry off what I was hearing in my head.
Oh,
anyway, I'll shut up.
I don't know if I can do another accent.
All right, that's fine.
Next delay question. That when I strike the question. Strike the request.
Next question.
Okay. I'm assuming it's for both of you two.
Okay.
What can a man do to possibly improve your odds to get custody or partial custody of your child during a custody battle?
Too many things to list.
You want me to start out?
Actually, if you start out, I may be able to flesh things out a little bit down the line.
Yeah, no problem. The first thing you need to do is you need to understand that in order to protect your kids to get custody, you need to take your emotions out of this. And you need to go as non-emotive as possible, which is what this means is if you're in the middle of a litigation, you cannot be drinking. If you have a beer every night after work, or you have alcohol with your friends on the weekend, stop. If you do drugs, stop. I don't care who you are. If you can't do those things, you don't have the impulse control to protect your children. Secondly, the second most important thing in line is you have to have a good emotional support mechanism. Men isolate when they stress out. They isolate and they get depressed. The testosterone forces them into that isolation, and it creates lots of long-term mental health issues in men. This is one of the leading causes of suicide. It's one of the leading causes of homicide related to family law matters. You have to have that support mechanism. You have to have a place to break down, and you have to understand that you are going to break down. I don't give a shit who you are. You need to have a place to break down so that when the stress gets too bad, and it will, you go to that little place, whether it's your friend's house or, a cabin out in the woods that you like a summer cabin someplace. You have to be able to have that place to break down. Then you have to interview and get the best attorney that you can get for your money, and hopefully work for peace while preparing for war, and have that attorney prepare for that war and prepare for your appeal right in the beginning. And you also need to make sure to increase your odds that you have plenty of horsepower to do it. So in other words, have a bank account. And the other thing is, I need to say this as well, is that, as a father who has had custody of his children, has lost custody of his children and gained them back, if you don't have the legal knowledge right up front, don't fight the fight you can't win. There was a guy on the TFM show a couple weeks back who he was like, DDJ, you really inspired me. I'm going to get ready. I'm going to fight this trial. And he was feeling pretty good about it, even though he had questions. But the reality is that he didn't have the legal knowledge to be successful. The other side had an attorney. He didn't. He fired his attorney. And he was going to walk into a crucifixion.
Yeah.
And I told him, I said, look, you got to settle the case as quick as you can. You got to get out of court because they will crucify you. And if they crucify you, you're done. So you have to know when to fight and when not to fight. And you also need to make sure that you understand the other reality as well. And that is when men get into fight or flight mode, they get so caught up in the conflict, they forget that their children still need a father. So you have to make sure that you keep that relationship with your children strong. You need to be the man that your child will look up to. No matter what happens, at the end of the day, your children will see you for who you really are. even if they're damaged, even if they're fucked up, even if they're irreparably fucked up, they will know the kind of man you truly are. So those are the things that I would say.
Yeah, I would actually, as a addition to that, there's a Terrence Popp video that is absolutely 100% on point. I believe it's called The Long Game. Every man who's caught up in a scenario or even starting a scenario like that needs to watch that video. Terrence Popp is on point. He knows exactly what he's saying. And the objective is, it basically mirrors what DDJ just said. You cannot fight this fight without keeping in mind, yeah, okay, right now I really want to just put my thumbs in my ex's eyes and set her on fire. But you can't do that. You're not going to be doing your kids any good behind bars. You're just not. And you got to keep your temper as much as under control as you can. The fight or flight instinct will 9 times out of 10 in court kill you. You just can't. You cannot succumb to that. You cannot have outbursts. Keep in mind that everything that goes into text or an email is admissible potentially, and you really don't want that stuff to show. I mean, I've had cases that turned on it. The fact that the crazy ex was screeching and yelling and pulling her hair and gnashing her teeth and pointing to texts, and the truth of the matter is the texts that she was pointing to proved that she was a lunatic. And when the judge and the GAL in that particular case looked at it, it didn't back her up, despite the fact that she was making all sorts of bullshit allegations. So just don't put things in writing like that. Be as reasonable as you can, no matter how crazy she is, and set out a path, a documented path where you're not the one who's acting crazy.
Right.
And that will serve you very well in court.
And let me jump on another thing that's I think is just as important. If your ex sees that she's losing, don't be surprised if she tries to turn the sex back on. Don't be surprised if she tries to maybe we need to see about being separated for a while and get back together. Listen, that's danger. Stay the fuck away from that.
Yeah, absolutely. I love TFM's remark. I really do. Yeah, exactly.
Yeah. So, but my point is it like there was a guy that in TFM's show.
And you're right. They do turn that back on, and they'll try damn near anything. That's where the allegations, the bullshit allegations come. And at a certain point, you're going to have somebody back in your play being with you so that they can say, yeah, he was over here. He wasn't out, beating her up. If she decided to walk into a window or walk into a wall, that's, he was here. He wasn't there.
Yeah.
It's just in the really horrific cases, that's what you need. You need somebody to back you up, to show that you weren't where they say you were. You were at work, and your coworkers can vouch for your whereabouts. And it gets horrific. And you really have to, and once those bullshit allegations start coming, if they're going to come, you need to crush them. You really need to crush those allegations so that they don't come back again. Remember the axiom: what gets rewarded gets repeated. You got to make sure those things do not get rewarded.
Right. You go scorched earth. Always.
Yeah. You don't try to settle it. You don't try to settle after one of those allegations, because you're never gonna get away with those. If you back down because there's an allegation, you're going to get another allegation coming down the pipe at some point.
Okay.
But if you gear up and make it very clear that you are willing to completely leave a crater where they were standing, metaphorically speaking,
right?
They kind of flies in the face of what I just said about being reasonable.
Right.
But if you're going to metaphorically leave a crater and just ruin their credibility, they're not going to do it again. So,
but that's a reasonable response to an unreasonable situation. That's the point.
It is. It gets back to the if you seek peace, prepare for war.
Right.
If your ex is offering reasonable offers, take them. Don't go scorched earth on a reasonable ex. They're very rare, but I've seen them. They exist.
They do.
And I'm not calling them a NAWALT by any stretch. They're not. They're all fucking. But it doesn't. Even a crazy bitch can act sane once in a while. Even a blind squirrel finds a nut once in a while.
Exactly.
So if they're behaving themselves and they're willing to put it in writing, take advantage of that and take the reasonable offer.
Yep.
So
and the longer you litigate, the worse it is.
It's always going to get worse. So if you can get a decent, fair settlement arrangement, take it, because otherwise, I don't encourage anybody. There was a long period of time where I just said, forget it. The legal system's not where you should be going. Because if you can find any other solution, but better than the court, take it. Don't go to court if you can avoid it. It's not a good place for anybody. And I'm a lawyer. I make my bread and butter from people going into court. But the truth of the matter is, it doesn't really serve anybody that well. Broken system. We just fix things that are even more broken than the systems themselves.
Right. Well, and the best lawyers are the ones that you hire that help you negotiate out of court and get a reasonable settlement.
Long before any complaints are filed. Those are the best. They're awesome when they happen. But most of the cases I have are there's a crazy ex in the wood. There's some lunacy going on, and it's just it can't be fixed. It's already gone on too long, and things have gotten too hairy before it comes to me.
Right. So it's funny you mentioned that too, because I used to get a lot of cases where the ship had already turned sideways, the guy had already spent $20,000 to $50,000, and their case is completely fucked, and you just got to turn the ship right side up. And again, it's because of a lot of ignorance, and there's a lot. It's not just one person's fault, other than the bad faith in the court system and the bad faith of the feminist saturated attorneys that are there. But it's just that's a really common thing. So that's one of the goals of these layman's legal clinics, is to teach people, kind of give them a little bit of self-help and to give them a little bit of education, so that when they do go to court or when they do look for an attorney, they at least have some additional resources that they can draw on.
Yes, absolutely. And it's critical. But, the only thing I worry about with these kind of things, and I know the good news is that, MGTOWs, as a general rule, they're not the dumbest. They're not the dumbest. They're pretty damn clever and bright. They do understand that there's something going on that's not fair. So as a consequence, that they understand when you tell them, even though they may not have the money, they'll understand that, you really don't want to go into court alone. You want to go in with somebody back in your play as an attorney, because 9 times out of 10, trying any of the tricks that you and I suggest, if you're representing yourself, they're not going to work, because the court and the other attorney isn't going to play ball, because they don't have to. They have to look out for the interests of their client, or they have to be impartial, one or the other. And judges are notorious. They're notorious for not liking pro se people representing themselves. They're notorious for it,
right?
And because it screws with clearing their calendar and settling their cases. And that's the one of the guiding lights for judges, is getting cases in and through quickly.
Right.
So yeah.
Exactly. All right, Lily.
I think we got kind of far afield. I'm sorry. Go ahead.
No. That's perfect. I think that's all good information, and I think it's definitely relevant to the conversation today. So feel free. Lily, what's our next question, if we have one?
All right, our next question. I'm assuming it's for both of you. Is it better to get a female attorney to represent you, or a male, or does gender not matter in selecting a family law attorney?
That's an interesting question, and it's something that's a case by case.
I would agree with that.
If you're a big guy,
you want a woman.
If you're a big guy and you're being hit by domestic violence allegations, you want a woman. But you got to be really careful when you do the interviewing process for the female attorney. You get a rabid feminist attorney, she's not going to do you any good. You want a female attorney who isn't a rabid feminist, and that's hard as hell to find. That's it's just because I have my doubts about whether a rabid feminist attorney could defend somebody from a domestic violence allegation. I don't know if they can divorce themselves well enough from their ideology to not just basically throw you to the wolves.
I don't think they can. I'll tell you what I do when I have to look for a female attorney. Find one who's married.
Yes.
Find a female attorney who's married, and that she's got a reasonably sized rock on her hand. Because here's the thing, that means that there's a good chance she's a trad thought, and a trad thought who hates feminists and hates the whole DV thing is more likely to defend you than one who's not. Don't find the most attractive woman that's out there, but find one that knows how to do her makeup. because she knows how to present herself. Basically, what you're looking for is you're looking for a traditionalist / conservative attorney. You know, and when you talk to her, like if you're in the office and you're talking to her and you talk about some of the guy stuff you do and she kind of resonates with that, it's probably because she's more traditional. So like one of the things that I used to tell guys to do is talk about shooting and hunting and stuff like that. And if she cringes, that's not the attorney for you.
Right.
You can find it, but if she does like hunting, she does like fishing, she does like those things.
Hell, even if she likes preparing things like venison stew, that means she may not actually like participating in it, but she doesn't hate people who do it. You know, a trad thought female attorney is actually not a bad thing to have on your side. So, but you want somebody you really don't. A rabid feminist. You know, I've known some feminist attorneys who were, well, they were good attorneys. They were able to do what they needed to do without. And it's not a common thing. A feminist attorney who is not that rabid is okay, but you got to be darn careful with them. But I think your initial remark there about them being married, that's a key point. If they're not able to stay married and they're divorced, odds are good they're not worth a bucket of shit.
Yeah, exactly. So I think we've got one last question from TFM. Go for it, Lily.
We do. It's actually beautiful. Okay. What if I represented myself but dressed Celestina up in a suit and had her be my attorney while I spoke through her?
They don't allow chimps in courts.
Oh, God.
That's true, but I'll tell you what, TFM, one of the key things you have to do is you have to make sure that the anal portal in the back goes all the way up to the mouth so you can actually make her mouth move by sticking your arm up there. If you can do that, you dress her in a nice dress suit with a skirt, then I think you might be able to make that play.
There you go. Pro tip from the attorney. and the best part about it is you need a whole lot more than the tip to make it work.
Oh yeah. Oh yeah.
All right, guys, I think that is everything. Thank you for checking out the stream today. Thank you for coming to the Layman's Legal Clinic. MGTOW Esquire, thank you for showing up.
Thank you for having me. This is a blast.
Absolutely. And, you know, as things come up and as time allows, you know, definitely we'll be continuing these for those people that are interested. If you want to keep updated or you're relatively new to my channel, check me out on YouTube. If you look at the upper right-hand side of the screen, I'm the author of the Amazon bestseller, The Feminist Lie. It Was Never About Equality, under the pen name Bob Lewis. Check out my website at misandrytoday.com. And if you want to support my work, you can definitely do so on Patreon as well. And feel free to check out my sponsor, The Dollhouse. If you go to misandrytoday.com, there's a direct link there, and you can check them out as well. With that, also, Lily, thank you for fielding the Q&A today. You're turning out to be a very trainable Q&A thought. So thank you.
Did you just try to call me a tradcon?
I was going to say trad thought, but that's okay. I know better.
That's funny.
So yeah. So with that, everybody, I hope you guys have a great afternoon. I'll go ahead and do some post-production of this, and it should upload sometime later today. Enjoy your afternoon and evening, guys.
Thanks.
Yep.
Bye.